Mark Mix. He's the president of the National Right to Work Foundation. And these, I'm a pro-union guy, by the way, anti-government unions and public unions. But it's good to know we've got groups like the National Right to Work Foundation out there fighting for the rights of workers, because it's not all about unions. And Mark is with us, and there's a recent case that came out about a Pennsylvania metal worker who was getting charged union dues when he didn't want them. Mark, welcome.
Bob, good to be on with you, and thanks for the opportunity to chat. I am excited to talk with you. I've got some kin that just over the Pennsylvania border in your listening area, so maybe they're tuned in today, although they may not like what I have to say. I don't know. We'll see.
Listen, if we worry about whether people will like what we have to say, we'd have to be silent.
That's right, Bob. And I presume, based on your introduction, that you're not silent, so it's good to be on with you today. And I'll just call you Bob, okay? Because that last name is confusing.
You feel free.
Okay. Yeah, no, this is an important case, Bob, and you're right. I mean, when we talk about labor policy in America, everyone kind of thinks it's one-sided, that it's labor union this, labor union that, and obviously we have federal laws that protect workers. We don't hear many of the stories about when a worker objects. In this case, we had an employee who came to us for free legal representation. He was a union steward, Bob, and he decided, based on what he saw inside the union, the Communication Workers of America, that he no longer wanted to basically pay them as a condition of his employment. Now, unfortunately, because Pennsylvania is not a right-to-work state, there are 27 right-to-work states today. There may be only 26 as of 5 o'clock today because Michigan's trying to repeal theirs. There's a hearing going on right now in Lansing. But in the 27 right-to-work states, you cannot be compelled to pay dues or fees to get or keep a job. In Pennsylvania,
I thought there was by the way, Mark, I thought there was a Supreme Court case, not directly on point for private sector workers, that if you didn't want to participate in the union, you didn't have to.
You're exactly right about that, Bob. You're on top of this. This is a case that we litigated here at the National Right to Work Legal Defense Foundation at the United States Supreme Court. We argued the case back in 2018, and the Supreme Court agreed with our argument that everything that government unions do is political speech. They're redressing government, trying to basically influence, and I'm using my finger quotes here, on what government, how they spend their money, and what they do from a standpoint of the terms and conditions of employment. And so they basically said that all government sector workers in America have First Amendment constitutional protections from being forced to pay a private organization for the right to work for their government. So we have a right to work law for all government sector employees across the nation. We've had that since 2018. But in the private sector, in states that don't have right to work laws, you can still be required to pay fees in order to keep your job. And that's what's happening here at this Catalus company over in Galeton.
Is that headed towards the Supreme Court so that this court can make a definitive decision on it? Because as I said, I'm pro-private sector unions, but not if the guy doesn't want to be in it.
Yeah, no, that's actually the point, Bob. You know, under the National Labor Relations Act, it was passed back in the 1930s, actually 1935, and then finally upheld by the Supreme Court in 1937. The federal law says that workers in Pennsylvania, back then it said you had to formally join a union. You had to join and be a member of a private organization in order to work, and then to add insult to injury, you had to pay these dues and fees. In 1963, the U.S. Supreme Court ruled in a case called NLRB versus General Motors. It said, well, you know, forcing workers to be a formal member of a private organization is probably a bridge too far for basic individual freedom. And so what we decided is you don't have to join the union, but you can be forced to pay up to 100% of dues or fees in order to keep your job. Well, that was the placemaker in 1963. In 1988, we actually did argue a case at the Supreme Court that is relevant to private sector employees. That's a case called Beck versus Communication Workers of America, the very union that we're talking about right here in this case in Pennsylvania. Mm-hmm. And that case said that you cannot be compelled to pay for the political or ideological agendas of a union. And, Bob, I hate to announce this to you, but unions are very political. They get involved in politics, and they spend a lot of money on politics because their power is as a derivative of government action, whether it be at the federal
and by the way, sometimes against the interest of their own workers, because they're so lockstep with the left and the Democrat Party that they overlook their own workers when they're getting engaged.
That's exactly right. And that's what happened in this case with the union steward. He looked at what they were up to and said, I don't want to be part of that anymore. And Bob, to your point, let's take a real quick example, the Keystone Pipeline. Remember that project that was going to bring new oil down to our refineries in the United States? That was a total union job. Every job on that construction project was a union job. And the Operating Engineers Union, which was representing many of the employees driving the bulldozers and the backhoes and all the things that were going on, basically knew that President Joe Biden said on the campaign trail that he would stop the construction of the Keystone Pipeline. Yet that political action committee for that union, the operating engineers, spent literally hundreds of thousands of dollars to promote Joe Biden to get to the White House. He gets to the White House 1 week later, he puts all of those operating engineer union members on the unemployment line. Same thing happened in the oil and gas and the extractive industries as well. I mean, you're exactly right. The agendas of the top union officials, whether they be in Washington, D.C. or Harrisburg, are a lot different than rank-and-file workers across the country. That's why they need protection.
So this Coates case that you prevailed upon, was that in Pennsylvania?
Yes, it was.
State
it was over
court
in Galeton.
Decision.
Yep. Well, no, it was a National Labor Relations Board settlement.
Okay.
And so it's the private sector labor law is adjudicated by the National Labor Relations Board and their regional offices. There's a regional office in Pittsburgh that investigated this, and the union wanted to settle because they knew they were wrong and they were violating the rights of this employee. And unfortunately, lots of employees are faced with this type of Hobson's choice. How do I protect my individual freedom and still protect my job? And in this case, we got the union to settle the case because they know if it went any farther, we might get to a place where the Supreme Court would look at it again and say, forcing someone to pay for things they don't like is not a very good idea.
We're talking with Mark Mix. He's the president of the National Right to Work Foundation. Mark Mix, tell me what is on the agenda with you, because we know that Biden appointees do not follow the law. I mean, we know it. So the National Labor Relations Board is not going to follow the law. They're not going to follow Supreme Court precedent. So you're going to have to fight in almost every instance.
Yeah, that's right. And, we have 21 staff attorneys that do nothing but help employees. And, I was just writing a report to our board of directors. We have 253 active cases last year, and we got another 160 actually active cases today, all on behalf of employees in their fight against a union and or their employer. I mean, in this case, the employer was not part of the problem. It was the union that was saying, hey, you can't resign union membership. You got to be a union. They actually said you have to be a union member, which has been illegal under a Supreme Court case going back to 1963. So, yeah.
Well,
lots of work to do, Bob.
You're right. Your work will never be done. Mark Mix, president of the National Right to Work Foundation, thank you so much for joining us. And listen, feel free to join us anytime an issue comes up. We'd love to hear your perspective.
Okay, Bob. Thanks. Is it Cordaro or Cordaro?
Cordaro, but we answer to anything.
Gotcha. Thanks, Bob.
Yeah, just because you're lucky with a name like Mix.
Yeah, right. That's right. Thank you, Bob.
All right, Mark Mix. Thank you very much.